9 times. 9 times. Donald Trump was found in contempt 9 times. And that was just the tip of the iceberg for the craziness that happened in the first week of the felony New York hush money trial. But chaos lawyer and Trump whisperer Liz Dye explains the real consequences that this has had on Trump in his trial.
Thanks, Devin. Justice Merchan runs a tight ship, so it took him just 3 days to select 12 jurors and 6 alternates in Trump's trial for falsifying business records to cover up the hush money payment to adult film star Stormy Daniels. Trump is bigly mad about having this case heard in New York, i.e. where the alleged crimes took place, and where he created those records, saying he'd paid attorney Michael Cohen for legal services which were never performed. In March, Trump filed a motion to postpone on the theory that potential jurors in New York County have been bombarded with online media coverage. To be clear, Dzhokhar Tsarnaev, aka the Boston Marathon bomber, tried and failed to get his trial moved out of Boston by arguing that everyone there hated him. So it was always going to be a heavy lift to get away from Manhattan just because voters in New York County voted overwhelmingly in favor of President Trump's opponents in the 2016 and 2020 elections, particularly when Trump himself is the source of a great deal of publicity about his case, complaining about it multiple times a day on social media and on television. Justice Merchan denied the motion to postpone, noting that the situation defendant finds himself in now is not new to him, and at least in part of his own doing, thanks to unrelenting media posts attacking those he perceived to be responsible for his plight. There's also Trump's habit of holding press conferences outside the courtroom. But that didn't stop Trump's lawyers from filing 2 emergency appeals based on significant prejudice against President Trump that permeates the jury pool. Survey says... So instead, he pivoted to attacking the jurors, potentially violating the gag order imposed on March 26. Trump was already scheduled to come before the court on Tuesday to explain why his attacks on Michael Cohen and Stormy Daniels didn't violate that gag order, so prosecutors just added his other posts about the jury to the pile. But before that, on Monday, they had to get through opening statements as well as a major ruling, which will likely impact Trump's decision to take the witness stand in his own defense and subject himself to cross-examination. On Friday, the court held what's known as a Sandimmune hearing. Not quite. In New York, the standard for deciding whether prosecutors can impeach a defendant's credibility on the witness stand by asking about prior specific criminal, vicious, and immoral acts was first articulated in a 1974 case called People v. Sandoval. Because if you tell the jurors about other horrible stuff that the defendant did, they'll infer not just that he's a liar, but that he's such a bad guy that he must be guilty of the crime charged, irrespective of the evidence before them. So, before a defendant decides whether or not he wants to take the stand and waive his right not to testify, he should know what prior bad acts he's going to be asked about. And with Trump, there are a whole lot of bad acts that the prosecutors want to discuss. Specifically, they want to bring up the civil fraud ruling that he repeatedly and persistently falsified business records and testified untruthfully under oath, and the 2 E. Jean Carroll defamation cases where he was found liable for defaming and sexually assaulting the plaintiff and fined first $5 million, then $83 million, and the civil RICO suit he filed against Hillary Clinton, which cost him almost $1 million in sanctions after the judge called him a mastermind of strategic abuse of the judicial process, and the criminal indictment of the Trump Organization on 17 felony counts of tax fraud and falsifying business records, and the 2019 civil action dissolving the Trump Foundation after Trump got caught using charitable funds to support his political campaign. With substantial restrictions, Justice Merchan said he'd allow prosecutors to question Trump about the civil fraud verdict of $464 million, the $88 million he owes Carroll because he lied about her in public, and the dissolution of the Trump Foundation.
Mr. President, do you plan to testify?
Yeah, I would testify, absolutely.
For the record, I'll believe it when I see it. Trump promised to testify in his civil fraud case and backed out, and when he did take the stand in the second E. Jean Carroll case, the jury fined him $83 million. After the judge announced his Sandoval ruling from the bench on Monday, he brought in the jury and gave them lengthy instructions to avoid media coverage and not to speak about the trial. The interlude provided the defendant with a convenient break for his morning nap. Then, Assistant District Attorney Matthew Colangelo gave the prosecution's opening statement, stressing that Trump conspired to hide the payoff to Daniels because he thought she'd tank his electoral prospects by revealing that he'd had a sexual liaison with a porn star while his wife was home with their infant child. Colangelo began by telling the jurors that the defendant orchestrated a criminal scheme to corrupt the 2016 presidential election. Then he covered up that criminal conspiracy by lying on his New York business records over and over and over again. He previewed testimony by David Pecker, the former CEO of American Media, the parent company of the National Enquirer. Pecker met with Trump and Michael Cohen at Trump Tower and agreed to gather information that might be harmful to Trump's candidacy and prevent that information from becoming public, while at the same time publishing flattering stories about Trump and attacking his political opponents. Colangelo quoted the Access Hollywood tape and promised jurors that they'd hear from Trump's aide Hope Hicks about the panic it set off inside the Trump campaign, which was the impetus for Cohen taking $130,000 out of the home equity line of credit on his personal residence to get the cash to buy Daniel's silence. After the election, Cohen sent a series of sham invoices for legal work, which the Trump Organization recorded on its ledgers with corresponding false notations and then generated checks to make Cohen whole. The prosecutor called it election fraud, pure and simple, and urged the jurors to tune out the noise and focus on the facts, after which Trump's lawyer, Todd Blanche, took to the floor to explain that his client is cloaked in innocence and calling the prosecutor's narrative untrue and promising that at the end of this trial, there will be plenty of reasonable doubt. In Blanche's telling, Trump knew nothing about the false invoices generated by Cohen. His underlings at the Trump Organization just paid the bills because they trusted Cohen after his many years of faithful service. This was somewhat undercut when Blanche immediately followed up by calling Cohen a liar who can't be trusted and urging the jurors to disregard everything he said. Blanche insisted that Trump had nothing to do with any of the 34 pieces of paper, the 34 counts, except he signed onto the checks in the White House while he was running the country, and that's not a crime. Blanche also took the position that Daniels was lying about the long-ago encounter as part of a sinister attempt to extort Trump, who simply fought back to protect his family, his reputation, and his brand. Trump, whose extramarital affairs were tabloid fodder for decades, was falsely accused and simply paid these women off to protect his beloved wife, Melania. Tuesday morning started off with a hearing on the gag order that Trump keeps violating. Last month, Justice Merchan barred Trump from speaking publicly about jurors, line prosecutors, and witnesses in this case with respect to their potential testimony. Since then, Trump has posted dozens of articles on Truth Social and his campaign website attacking Cohen's credibility and calling him a serial perjurer. He posted a link to a 2018 statement by Daniels denying their encounter, falsely describing it as newly discovered evidence. And he quoted Fox's Jesse Waters saying that the jury was full of secret liberal activists. The prosecutors moved to hold Trump in contempt, asking for $1,000 per violation under New York Judiciary Law, Section 751, which allows for a fine not exceeding $1,000 or imprisonment not exceeding 30 days in jail. Justice Merchan agreed to hold a hearing Tuesday, after which Trump wandered out of the courtroom and called Cohen a liar in the hallway while talking to reporters from every major media outlet on earth. All of this forced Trump's lawyers to take the bizarre position that reposting articles and quoting someone else attacking witnesses and jurors somehow doesn't violate the gag order. RTs are not endorsements? The court ordered Blanche to tell me what case law you have to support that, at which point the attorney was forced to admit that he did not have any case law to support that, but it's just common sense, Your Honor. He also suggested that the prosecution had somehow forfeited its right to complain about reposts by failing to bring a motion for contempt every single time Trump links to an article that violates the gag order. Blanche insisted that his client was being very careful to comply with the court's rules, to which Justice Merchan responded, "Mr. Blanche, you are losing all credibility with the court." On Thursday morning, prosecutors submitted yet another request to find Trump in contempt, citing 3 more violations of the gag order, including one from Monday morning when Trump walked out of the courtroom and called Michael Cohen a liar again.
And when are they going to look at all the lies that Cohen did in the last trial? He got caught lying in the last trial. So he got caught lying, pure lying.
Justice Merchan signed the order and set a hearing for the following week. So we'll get to see Blanche take another crack at explaining why claiming that the jury is 95% Democrat and calling Cohen a convicted liar who's got no credibility doesn't violate the ban on public statements about witnesses and jurors. Trump's big mouth has caused innumerable problems for his lawyers, including hampering their ability to properly cross-examine witnesses. That's because the prosecutors have refused to say in advance which witnesses will testify when, functionally forcing Trump's team to prep for all of them at once. On April 18, Assistant District Attorney Joshua Steinglass refused to provide the names of the first 3 witnesses he intended to call, since Trump has been attacking the witnesses on social media and he didn't want to risk it. Justice Merchan agreed that he couldn't fault the prosecutors for that one. And even though Blanche promised that he'd make sure that there were no more public attacks on the witnesses, the judge said he didn't believe Blanche could honestly make that representation, which is not really a great endorsement of your client management skills.
Hey, sorry to interrupt, Liz, but if your Sandimmune Hearing lets in a whole bunch of negative past bad acts regarding your untruthfulness, you're probably going to want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you or a loved one is suffering from mesothelioma, because asbestos exposure can take decades, or if you've suffered a data breach, especially if you got one of those data breach letters, or were involved in a car crash or just about anything else, we can represent you or help find you the right attorney who can. It's so important to talk to a lawyer early in the process to learn what your options are and maximize your recovery. So just click on the link in the description or call the number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. The link is below.
The first witness to testify was David Pecker, who spent 4 days on the stand describing his long relationship with Donald Trump as they both navigated the world of celebrity gossip in New York. In 2015, after Trump announced he was running for president, he invited Pecker to a meeting in Trump Tower to ask what his magazine could do to help the campaign. Pecker volunteered that he would publish positive stories about Mr. Trump and negative stories about his opponents, and that he would be the Trump campaign's eyes and ears looking out for women selling stories. And Pecker was as good as his word. He dutifully churned out headlines calling Trump the healthiest individual ever elected and claiming that John F. Kennedy's secret son had endorsed him. During the primary, Cohen would call up Pecker and order up negative articles on whichever of Trump's Republican opponents was rising in the polls. And Pecker would serve up stories accusing Dr. Ben Carson of medical malpractice, or reporting that Marco Rubio had a secret love child, or saying that Ted Cruz was philandering with porn stars. That one's maybe a little too on the nose. Originally, the parties agreed that Pecker would tell Cohen if someone was shopping around a negative story on Trump, and Cohen would deal with it. But the first story Pecker found was a doorman who alleged that Trump had fathered a secret love child with a cleaner at Trump Tower. Pecker admitted under oath that he knew that story wasn't true, but he still paid $30,000 for it to ensure that it didn't get published anywhere else, which would have been very embarrassing to the Trump campaign. Then came Karen McDougal, a former Playboy model who had a relationship with Trump in 2006 when Melania Trump was pregnant with their son Barron. In August of 2016, AMI paid McDougal $150,000 for her limited life story rights, ensuring that only Pecker could publish details of any romantic, personal, and/or physical relationship McDougal has ever had with any then-married man. McDougal hoped to revive her career as a fitness influencer, and the deal specified that she would write regular columns for Inquirer's sister publications such as Star Magazine and Radar Online. Pecker testified that he agreed to let McDougal write articles because he wanted to make the contract look more legitimate. But McDougal's byline only appeared a few times in AMI publications, and Pecker admitted that he bought her story so it wouldn't be published by any other organization because he did not want her to embarrass Trump or hurt his campaign. Pecker and Cohen were in regular communication that fall, and Cohen told Pecker to pay McDougal, saying, "Don't worry, I'm your friend, the boss will take care of it." I'm pretty sure he didn't mean Bruce Springsteen. In September, Pecker drew up an agreement to sell McDougal's story to Trump for $125,000 through a company called Resolution Consultants. But after talking to his lawyers, Pecker refused to go through with it. Cohen was furious and screamed at Pecker that the boss is going to be very angry at you. But Pecker refused to budge. Then in October, just after the Access Hollywood tape dropped, Stormy Daniels approached the Inquirer and offered to sell her story for $120,000. But Pecker said no because he thought that associating his tabloid with a porn star would upset Walmart, his biggest distributor. And that's why Cohen did the deal himself. Pecker also confirmed that Cohen complained to him after the election that Trump had not paid him back for the $130,000 he'd fronted to Daniels. In 2018, federal investigators came knocking, but Cohen assured Pecker that he had nothing to worry about because Jeff Sessions is the Attorney General and Donald Trump has him in his pocket. That turned out to be a bad bet. And in 2016, Pecker reached a no prosecution agreement with the Justice Department in which he acknowledged the campaign finance violation and promised to testify in any future prosecution. It also turned out to be a bad bet for Jeff Sessions, who got fired the day after the 2018 midterms and lost the race to get his old seat back in 2020 after Trump endorsed Tommy Tuberville in the primary. On Friday, Trump's lawyer Emile Beauvais tried very hard to make Pecker admit on the stand that he only settled with the Justice Department to protect AMI's bottom line. He also suggested it was standard operating procedure for Pecker to buy up the stories and not publish them, and that it was done to benefit AMI, not the Trump campaign. Late Friday afternoon, Pecker concluded his testimony and was followed by Trump's former assistant, Rona Graff. Graff testified that she'd seen Stormy Daniels at Trump Tower and understood that the adult film star hoped to be a contestant on The Apprentice. She also confirmed that Trump's phone had contact info for both Daniels and McDougal in it. Graff was followed by a banker named Gary Farrow, who confirmed the details of Cohen moving money around to fund the Daniels payoff on the eve of the election, in 2016. Outside the courtroom, Trump and his fans continued to express their rage at Trump being treated like a normal criminal defendant. Trump complained about being forced to show up in court on his wife's birthday, even as his buddy Alan Dershowitz explained to Sean Hannity that it's unconstitutional to require the defendant's presence at his own criminal trial.
But the statute says, quote, in the absence of an objection by the people. In other words, the prosecution has a veto over the judge's decision whether to allow him to leave the courtroom in any given day. That is unconstitutional.
Dersh followed up by explaining that it's also unconstitutional to prevent defendants from publicly trash-talking the witnesses. This man taught for decades at Harvard Law. Meanwhile, over at Fox, Waters ranted that Trump is being treated worse than detainees at Gitmo and compared him to King Kong in a cage.
They trapped him in a cage. We call it a courtroom, but it's a cage. And he's like King Kong.
Because who can forget a famous horror movie where a giant gorilla terrorized New York by paying off a porn star and then taking random public naps? Luckily, there's only about a month of this nonsense left to go. Trump was held in contempt with respect to 9 of the first 10 alleged violations. As to his argument that retweets do not equal endorsements, the judge agreed that it was indeed an issue of common sense, but not in the way the defendant was hoping. The judge said the issue of reposting appears to be a question of first impression, and lacking legal authority to guide its decision, this court must, as defense counsel stated at the hearing, rely on common sense. Then he went on to note that Trump himself describes Truth Social as the primary way I get the word out because whatever he posts there spreads all over the place, fast and furious. And so there can be no doubt whatsoever that defendant's intent and purpose when reposting is to communicate to his audience that he endorses and adopts the posted statements as his own. So reposting someone else calling Michael Cohen a serial perjurer still counts. Plus, the quote attributed to Jesse Waters wasn't even stuff that Waters himself had said. It was just Trump making stuff up and putting it in Waters' mouth. And so the court fined Trump $1,000 per post. Okay, $1,000 to a billionaire is like a buck to anyone else. It's functionally nothing, less annoying than a parking ticket, and Justice Merchan is well aware of that. But his hands are tied because Section 751 provides him exactly 2 options here if he finds a party in contempt: a $1,000 fine or jail for up to 30 days. And neither one of those options is great. Justice Merchan noted that while $1,000 may suffice in most instances to protect the dignity of the judicial system, to compel respect for its mandates, and to punish the offender for disobeying a court order, it unfortunately will not achieve the desired result in these instances where the contemner can easily afford such a fine. Contemner is law talk for somebody found in contempt of court, a club which now includes Donald Trump. The judge said he'd like to impose a higher fine, which would act as an actual deterrent for someone with a 10-figure net worth. But since that's not an option, jail may be a necessary punishment. Defendant is hereby warned that the court will not tolerate continued willful violations of its lawful orders, and if necessary and appropriate under the circumstances, it will impose an incarceratory punishment. So the judge gave Trump until 2:15 that afternoon to take down the offending post, which, to his very minimal credit, he did, but the former president has shown no inclination or even ability to moderate his behavior in light of the court's prior order. So if we find ourselves back here again, Trump is quite likely to face at least a short term of confinement, even if only for a few hours while the court is in recess for lunch. And ABC News reports that the Secret Service is already planning for just such a contingency, since it's obligated to guard protectees 24/7 wherever their big mouths may take them. Meanwhile, Trump has returned to screaming about the illegal gag order, which is election interference by a rigged judge, blah, blah, blah. But for the time being, he's not pushing it any further than that.
And it's going to be interesting to see if he can hold his tongue. So far, he's been lashing out at others, but not the New York jury and the witnesses. Though history has shown that Trump can rein it in at least a little when the consequences are dire enough, as we saw in the aftermath of the E. Jean Carroll case, though even there he's walking that back. But if he does violate the gag order and goes to jail, he's really going to miss having a good meal. But when he gets out, he can have delicious meals delivered straight to his door with today's sponsor, Factor. And maybe lose a few pounds while he's at it, because Factor makes meeting your nutrition goals easier than ever by delivering fresh, never frozen, dietitian-approved meals right to your doorstep. And the meals are completely ready to eat in just 2 minutes. You can eliminate the hours it would take to shop, meal prep, and cook, so you can spend your day doing the things that you actually want to do. Plus, you'll never get bored with what you're eating. You can choose from over 35 different options a week, including ones that are keto, calorie smart, vegan, and veggie, and more. And on top of that, Factor offers 55 add-ons that that help make your weeknights even more delicious and nutritious. And now Factor's offering 2 free wellness shots with each order for life while you're an active subscriber. Factor meals arrive at your door pre-prepared and ready to eat in just 2 minutes. In the same amount of time that I can even think about going to the grocery store, my Factor meal is already done. Because sometimes I just want a good, healthy meal without having to cook, and it's surprisingly affordable. And now Factor offers Gourmet Plus meals as part of your weekly options, so you can get a little fancy with your meal if you're craving something special, because you deserve it. Gourmet meals include surf and turf or surf and surf shrimp and salmon, but honestly, you can't go wrong with their normal offerings either. Factor's team of gourmet chefs helps create each meal to help you feel your best all day long, and they really are extremely delicious. Like my favorites including bruschetta shrimp risotto, green goddess chicken, and grilled steakhouse filet mignon. And I get to eat them every week if I want to. And Factor's flexible. You can pause or reschedule your deliveries at any time. So click on the link that's on screen right now or down below and use the code LegalEagle50 to get 50% off your first Factor box with free wellness shots for life. Again, just click on the link that's on screen or down below and use the code LegalEagle50 to get 50% off your first Factor box. After that, click on this box over here for more Legal Eagle, or I'll see you in court.